When then 15-year-old Ethan Crumbley shot and killed 4 students at Oxford High School in Pontiac, Michigan. It was the worst school shooting in the state's history.
Last month, when his mother, Jennifer, was found guilty of 4 counts of involuntary manslaughter, she became the first parent in this country to ever be held criminally responsible for a school shooting carried out by their child. Today, Ethan Crumbley's dad, James, goes on trial as well, facing the same 4 counts, in fact, one for each of the students killed that day. Joining us now to talk about Chapter 2 of this very unusual and fundamentally disturbing case is renowned criminal defense attorney Joseph Tully. Joseph, thank you so much for giving us some time here in Morning Rush. We certainly appreciate it. Same shooting, same set of parents, same circumstances. Do we expect a different result than what mom got?
I wouldn't expect a different result, but I would expect a different process. So in a case where a co-defendant has already been tried and already been found guilty, the next trial to go forward has that data, that intelligence to inform how their defense should go. So I do think they will definitely be taking a drastic tactic than the defense for the mother did, because that didn't work.
So there is something to be said. If you go second, you kind of learn from the lessons before. Is there anything, I guess, that the mom did that the dad did not do, that the sentencing may be different, or anything that comes to that?
Sure. So I think that we'll see during the defense, going second and learning from the first trial, the defense team for the father will have to distinguish the father's actions from the mother's actions. Now, the father did buy the gun, did sign something under penalty of perjury saying that, or acknowledging that it was illegal to buy the gun for someone else, and did share, part of the responsibility in terms of, not locking the gun up, and was at the school when the school officials had the parents with the son, or had a meeting with the parents and the son and discussed what was going on, and the mother and father both left. However, the defense team will have to argue that the father wasn't as close with the son, that he didn't have as much communication and as much responsibility in terms of keeping the son away from the gun. And basically, he didn't know. The mother was in a better position to know. The father was in a worse position to know.
Beyond the specific details of this case, as a general principle, and obviously you're a defense attorney, do you think that holding the parents of school shooters criminally liable, do you think that is a good trend, an effective deterrent to stop in a country where we see this quite regularly, more than any other country? Is this the right approach legally, morally, from your opinion?
So I do not believe that this is the right approach. Number one, the prosecutors charged the son as an adult, and they did that so that they could get the maximum penalty. However, in prosecuting the parents, they're saying this was their son, this was a minor, and the parents have to be responsible. Those theories are completely inconsistent. However, the parents will not work, the mother was not allowed to argue that, and the father will not be allowed to argue that. It would be a bulletproof argument. The government can't argue out of both sides of its mouth. What they're doing here is creating a slippery slope where parents can be responsible for acts of their children. And I think here the connection is a little bit too far. And I think you hit the nail on the head. What is happening is people are saying, I'm sick of school shootings. I'm sick of mass shootings in general. Somebody has to step up. And until we make somebody responsible, we're not going to have change. So even though these parents should not legally be tried and prosecuted and sentenced, everybody's kind of looking the other way because we want the result. We want it out there that, people need to take responsibility, and maybe that will change things. But I think that is going down a slippery slope that is very dangerous.
It's an understandable frustration, as much bloodshed as we've seen in this country. I'm curious too. Lawyers always argue, they get into the weeds of the law and this and that, and that's the way the process should work. I always try to put myself in the juror's mindset. It's just a non-lawyer, someone just listening. And when you really get into the details of the case, two things stick out. They had a meeting at the school the day of the shooting, mom and dad. The gun was in the bag. The gun that dad said he bought you, with the school saying, there's some dark stuff going on with your son. And still the shooting happened. And then after the shooting was happened, these two parents, for those who remember the story, went on the lam, got money out of the ATM and drove away while their son was in jail after gunning down 4 classmates, facing murder charges. From a common sense perspective, if I'm in that jury box, I go, oh my God, what the hell were these parents doing?
Right.
And at that point, in my mind, as a juror in that case, guilty as the day is long.
Okay. The response is there were teachers and administrators at that meeting. And yes, the gun was in the backpack. And the teachers and administrators, if they felt the need to, would have checked that backpack. The administrators did not insist on sending the son home. They said, it's an option. Do you want to take your son home, yes or no? And both of the parents, given that option, said no. If trained counselors and school administrators did not see an immediate threat, then how did the parents know that? They
bought him the gun.
The shooter lied. What?
They bought him the gun. The school didn't know that.
They bought him
Dad
the gun.
knew I bought I'm Dad. I bought the gun. And then the school telling me, oh, your kid's having some issues. I make that connection immediately and go, let's go home and let's get you some help. That's not what happened.
Yes, because the son is manipulative. The son said, I'm making a first-person shooter video game, which is very popular, and it fooled everybody there. It fooled the counselors just as much as it fooled the parents. So if the parents are being tried, then why wouldn't the counselors being tried? And the fact that the counselors who have training and could have the authority to have searched the backpack didn't do it, I think that creates a break in the chain in terms of causation with the parents.
But there's a certain, I guess, threshold. You know, you have this level of neglect from these parents, right, leading up to this. And the fact that a father can say, well, I don't know him as well as his mom does, so I don't really know what he's going through, is alarming. That would be a red flag to me. Do you think we're going to get to the point where, because you do have, you know, parents of shooters when in situations like this that say, I knew him so well, I did not see the red flags. I am a doting parent. We have a great relationship. And then you have just this stark difference in this case that we're seeing. Do you think that those should be equal then at any level when it comes to the parents? Because one, you have someone who's paying attention, and the other, you have people that are running away from the problem.
Sure. So I think that is, if that was the case here, I think that would be being argued that, look, you know, we are doting parents. We were well aware, and we did not see this. So keep in mind that the prosecution is charging them with involuntary manslaughter, and they have 2 different ways to do that: by gross negligence, as you alluded to, and then by willfully disregarding the threat that their child posed. So there's 2 different theories, and interestingly, the jury does not have to be unanimous. So six jurors can say, well, I believe the parents were grossly negligent. 6 jurors can say, we disagree with that, but we think that the parents willfully disregarded the son's dangerousness. And it could be a guilty verdict, even though it's not truly unanimous. So the government does have the ability to argue both of those theories, and the defense has to counter both of those theories, and the fact that the jury does not have to be unanimous on them.
And I guess, how do you prove the father saying, you know, I didn't know him that well? You can always prove when you do know someone that well with text messages, calls, things like that. How do you prove the opposite?
I mean,
you know,
it's
interesting.
Yeah, no, absolutely. And you alluded to it. There's a societal frustration with this kind of violence in our country, and people are anxious and eager and desperate for answers. And is it the school? Is it the guns? Is it mental health? Is it the parents? And going through all that is just tough terrain, but it's where we are. Criminal defense attorney Joseph Tully, thank you for a really important and tough conversation. Appreciate your time and your expertise.
Thank you very much.